Good afternoon, good evening, good morning, everybody. It is 3 p.m. UK time. Just had to check that, but it is definitely 3 p.m. UK time. If you can let me know where you're watching from, that would be great. We are doing a special today on copyright, or really a bit broader than that, all things legal, copyright, trademarks. We're going to talk to Jason Aquilino, who's a copyright expert, attorney. I'm going to bring him on here in a few minutes, but yeah, let's see who we've got. Julian is here. Hello to you. Kia is here from Gotham City. Bo from Ohio. Kathleen from NYC. Scott from an overcast Andalusia. And Eddie from Medan. Rhinebeast from Enfield, Connecticut. Cool. So thank you for joining me today. Like I said, we do have a special guest again, which is really cool. This is our second, I think, kind of interview session that we've done in the past few weeks. Lisa from Toronto is here. Rob from Johannesburg, South Africa. Brownie is here. Rika from Portugal. Cool. So yeah, let me just talk you through quickly what we're going to do today, because I feel like there's going to be an immense amount of questions, an immense amount of stuff we could talk about. So yeah, if you can, of course, please do like and subscribe. That would be wonderful. Today, we're going to talk about all things legal. We're going to talk about copyright registration, copyright infringement, how to deal with copycats, DMCA takedowns, all kinds of stuff, all kinds of fun stuff. The kind of stuff we don't usually talk about, but I think it's a topic that affects all of us in one way or another, and I think there's going to be a lot that you can get out of it today. So we will be bringing on Jason here in a second. I asked yesterday, or a few days ago, for people to send in questions, and I have been bombarded with different questions for Jason. So I do have a load of questions ready to go, but if you do have a question live and you want to ask it, while we're here today, then please, in this particular live stream, could you save it for later? I'm going to make sure we leave about 10 or 15 minutes towards the end, and that's just because we've got so many questions already that have come in. I think we're going to have plenty to talk about even before we get into live stuff. So yeah, if you have a question, feel free to comment, of course, and you can comment in the live chat and stuff like that. But I will be asking for questions maybe like 10 or 15 minutes before we wrap it up here today. Okay. Who else have we got here? Christy's here from Toledo. Nice to have you. And yes, one last thing. Jason has a free strategy session. If you are interested, if you've got specific legal issues that you need help with, maybe something that's too detailed for us to discuss here on the live stream today, michaelessek.com/Jason. You can register for a free strategy call there. I think a 20-minute call that Jason will do with you. And I would recommend that. I've used Jason for some legal issues. It's been very helpful. So if you do have specifics, that's the place to head. Okay. So without further ado, let me give a little intro to today's session and today's guest. Jason Aquilino, principal attorney at Aquilino Law, an expert in copyright issues, trademark issues, and he works a lot with artists and designers like ourselves, independent designers, independent artists, helping them protect their work, register their work for copyright and things like that, and then defending their work. So actually going out and actively, pursuing claims or trying to solve issues for artists and designers like us. So without further ado, let me bring on Jason, and we will get started here today. So welcome to Jason. How are you doing?
Hey, Michael. Doing great. How you doing?
I'm doing wonderful. Good. So for the benefit of everyone watching, why don't you give us a little bit of introduction to yourself and what it is that you do?
Sure. So I operate Aquilino Law, as you said. I work primarily with artists. I've been doing this for actually about 20 years this summer. So it's been a long time. Mostly in the art licensing field is where I got my start. So working with artists and art agencies, protecting copyrights, primarily, also with trademarks as well for brands and brand protection. A lot of art licensing agreements. So I work with artists to either draft their agreements or to negotiate agreements that they have with licensees. I also work with some licensors as well. So just any sort of IP rights, transfers, assignments, grants, that's the area that I work in, right? So yeah, I as I said, I got my start about 20 years ago, and just have kind of grown and recently have really focused on the art licensing area with I don't know, scores of artists as clients, mostly again helping them to protect their artwork and going after infringements. And we can kind of get more into the infringement pursuit later in the conversation, but that's the main focus. I also, just as an aside, am chief legal officer for a product or a service called Autonomo.com. And that is a service that sort of a subscription service. There's a free part of it too for artists to post and kind of create a portfolio online with the main objective of sort of showcasing your art and showing it off to potential licensees. And the more robust program of that allows you to sort of track licensees, track contracts, track royalties, allow licensees to sort of check out images so you can know if an image has an exclusive or non-exclusive license to it and things like that. So once you sort of grow and have enough where it gets a little complicated, and one of the major sort of dispute issues that I see when it comes to license agreements, right, is this idea of, you granted an exclusive license to one party, but then you accidentally maybe granted a non-exclusive to another party, and now there's some sort of conflict. So the Autonomo tool does a good job of helping you sort of avoid that and to track that, the use of your assets, if you will.
Yeah, no, that sounds good. That's something I've found myself, especially when you've got thousands of pieces of artwork and you're licensing them. It's like, oh, I just said I'd license that to this guy. Have I already licensed that to someone else exclusively? Or, I might have licensed it exclusively for a certain product, but not for that product. So yeah,
exactly.
It can get pretty complicated pretty fast. So yeah, that sounds good. Autonomo, you said, right?
Yep, Autonomo.
Okay, cool. I think, do you want to give us maybe just a little bit of a legal disclaimer? I mean, I know we're going to talk about kind of general advice here. But
yeah, I appreciate that. Yeah, absolutely. So, when you do these sort of presentations without a client, so I guess I should tell everybody who's watching either live or later on that obviously I'm not your attorney unless we've signed an engagement letter, right? So all of this is educational, as if you walked into a classroom and sat in on a law professor's discussion with the law students, if you will. Every issue, and as we go through these questions, you're going to sort of hear it again and again. Like, every issue is very sort of fact specific. So for me to sort of say something, this rule or that rule, you can't take it as legal advice, because your specific facts may be different. We don't have an attorney-client relationship, so I'm not advising everybody. And I'm talking off the cuff as well, so I very well could say something that's completely wrong. And so.
Yeah, I think a lot of some of these issues, they are. I get the question a lot. Is this okay? Is that not okay? What's fair use? When's a parody okay to do? Right. All those kind of questions. I've realized there are no black and white on these issues, and it all comes down to, the ultimate yes or no would be decided in a court or would be decided by a judge, and you can't find that out until it's gone to law in the first place. So yeah, I just want to make sure everyone's aware of that. This is obviously advice. We can give our opinions, and certainly Jason's opinion is going to be worth a lot more than mine. But don't take that as this gives me carte blanche to do this, or this is the green light to do this, or whatever. That's
right. You'll hear a lot of "it depends" today, and to be honest, even for my clients that I'm working with, a lot of times, I have to say it depends, but we go a little bit more granular, and we'll sort of talk about the risk, and I'll say, hey, if you if you were only to do this, I try to give guidance, say, if you were only to do this, I think you'd be much better off and you're going to minimize the risk. But there's no guarantee ever, because ultimately when you're doing something that has the potential of another party coming after you, they can be completely unreasonable. They can have deep pockets and they can decide to just sue you to the ground and bully you because, they want to flex their muscles and show people, hey, you can't even get 10 feet within my, intellectual property, and I'm going to prove it. Right. And then you're going to have to, maybe you're right, but then you'll have to take them to court and, that's expensive. Not cheap.
Yeah.
Right.
So I think in terms of like the questions we got and some questions I'd like to, or issues I'd like to discuss, we can kind of break them down into a few key areas. So the first one, I think, if we talk a little bit about creating work. So if we think about an artist sitting down to design something, let's talk about some of the things they can do and maybe they can't do. And one of the big questions we got, let me pull this one up just to kind of start with, is a question about using phrases. So how do I know if it's okay to use a phrase or a saying? So can a phrase, can text be copyrighted? What's your opinion on that one?
So I love this topic only because it's pretty complicated, and I'm going to say it depends, right? There's no perfect answer, but I can obviously get a little bit more in depth here. So if you were to just look at a basic primer for copyright, you're going to see that copyright does not protect short phrases. So the quick question is, well, what is a short phrase, right? Is that 3 words? Is that 6 words? Is that, could that be 8 words? Again, I think it sort of just depends on the phrase. There's court cases, dating back into like the early 20th century, where judge, I think it was Learned Hand. He's always a good judge to quote. He basically made a comment that there could be. Let's go back down to copyright. Copyright protects original and creative expression. So the general idea with short phrases is they're just too short to really have that level of creativity. However, that's not to say that a phrase couldn't be so creative that it has copyright protection. So now we're talking a little bit more into the hypothetical of this like amazing 3-word phrase that is just the most creative thing anybody's ever said. Potentially, you could argue that that there's protection in there. Interestingly, I think if you were to try to register that with the U.S. Copyright Office, it would probably be rejected. However, just because the Copyright Office will accept or reject a registration doesn't necessarily mean that you couldn't take it to court and sue. However, I say that, and the real answer to that is, however, you have to have a copyright registration in hand before you can actually file a lawsuit. So let's say that there's a phrase in a book that you like, say there was like this amazing, like you wrote a book about the Buddha or something, and you came up with this 3-word phrase that he said, and it just took off and became like, oh, this is the most wise thing in the world. And then somebody started putting it on t-shirts. And there's a copyright in the book. And so they sue, they say, this is my original phrase. It's very possible that could be ruled a copyright infringement. However, basic phrases like, hey, what's up? Or, sort of generic phrases, they don't get copyright protection, right? But now let's kind of go into another level. I've got a client that I registered a trademark for. She's a comedian who does YouTube videos, Heatherland. Her trademark is "I ain't doing it." So that sounds like a phrase that you could say, that's a short phrase. I can put that on a t-shirt, no problem. However, she has a trademark and "I ain't doing it" for t-shirts. So you can't use that phrase. So even if copyright, doesn't potentially protect a short phrase, you need to make sure that trademark doesn't protect it. Yeah. There was a court case that Here's Johnny, Johnny Carson, right? that actually using that phrase violated the right of publicity to Johnny Carson. So now right of publicity is another intellectual property right. Usually in celebrities, right of privacy is usually more for private citizens. But there's been rulings where even not just using the person's face, but any sort of symbol that's iconic with that particular person. Like there was a NASCAR racer who was famous. I don't know the case, but there's a case basically where they didn't show the person's face, but they showed a car that looked very similar to his iconic car. And people said, that's right. And they ruled that was a violation of that race car driver's right of publicity. You can imagine like maybe Evel Knievel, right? Some guy in a white, jumpsuit and a helmet on a motorcycle. You don't see Evel Knievel's face. You don't say his name, but everybody knows that's supposed to be Evel Knievel. And that could be a violation of his right of publicity as well. And right of publicity law is very fascinating topic. I don't know if there's questions about that in here or not, but to touch on it, right of publicity, pretty much everybody has a right of publicity, and I believe that carries on to the UK and the EU as well. What gets interesting is post-mortem rights of publicity, and that's where the law is all over the place with, depending on where the person passed away or where they were a resident of when they passed away, what was the right of publicity in that particular state or country at the time, how long does the postmortem right of publicity last? So like Marilyn Monroe has had cases just through the decades with rulings that, there was no right of publicity. I don't even know where it ended up at. I know that the Marilyn Monroe estate has trademarks now. So maybe you're no longer violating any right of publicity in Marilyn Monroe, but you're violating a trademark for Marilyn Monroe. So, there's, and then there's even like laws, while we're just kind of on the topic of all the jumble of different laws that you can kind of go down a rabbit hole. There's just misappropriation laws and unfair competition. So maybe something's not protected, per se by copyright or trademark or even right of publicity, but somebody could come after you with some sort of misappropriation that, this is my property, just sort of a common law. That's a little harder to do because of this sort of idea of what's common law and what's federal law and how federal law sort of trumps common law, but there's some creative ways to come at people with misappropriation claims as well.
Okay. So, well, yeah, there's a lot of different ways.
Could have went down a rabbit hole, didn't we?
It's a bit of a rabbit hole already. But there's a lot of different ways. That just highlights, simple question, or it seems like a simple question, can I, how do I know if it's okay to use a phrase or a saying? I think that comes down, there's obviously two sides to this. As artists, one side is, hey, I saw this phrase, or I saw this phrase on a tweet or something like that. Can I create a t-shirt design around it? That's one side of it. The other side is, hey, I came up with this phrase myself. This is my phrase or my joke. What can I do to protect that? And can other people steal that phrase and use it? So on that first one, I know some of the examples people had, and we had a couple of other kind of questions like lines from movies and TV shows and stuff like that. Now, personally, I'd say the safest bet is just to stay away from anything like that. Or alternatively, I've seen a lot of t-shirt designs where they'll take a phrase and they'll put a spin on it. So, for example, the famous one is, every now and then I fall apart, and it's a picture of a taco. So they've used, obviously, Bonnie Tyler's lyric, but they've transformed the meaning of it. It's clearly not a Bonnie Tyler t-shirt.
Right.
I would say, with my non-legal hat on, I think that's probably pretty safe. It's unlikely to be attacked. But I mean, what would your take on something like that be?
Yeah, it depends, right? But like, let's say I'll be back. That's a good example of, I think Arnold Schwarzenegger says I'll be back in like 8 different movies. Yeah. It's not just in the Terminator movie. Yeah. That could be a Here's Johnny for Arnold Schwarzenegger. Arnold Schwarzenegger, I hear, is a cool dude. Maybe he doesn't care. Maybe he doesn't. And actually, I thought of the phrase when I was sort of thinking about these topics, hasta la vista, baby, which was another famous Arnold Schwarzenegger quote, right? I just sort of start Googling for that, and I saw an article that said that, Arnold had registered a trademark for that. I guess probably closer to when Terminator 2 came out, which was, God knows how long ago.
A few years ago.
But so I was curious, because the way trademark works, this is sort of an interesting topic as well. The way trademark works is you don't just get a trademark and it's my trademark. Trademarks are done, in classes. So you can have a trademark for T-shirts, or you can have a trademark for soda pop, or you can have a trademark for plumbing services. But so as an example, I looked up Hasta La Vista Baby. I didn't see, because I was curious, what was it registered for? T-shirt, something else? I didn't even see any registration for Arnold Schwarzenegger. Interestingly, I saw an Hasta La Vista Baby trademark for fireworks, for a firework company. So, that kind of shows you that, who knows sometimes, right? But, a lot of times I think if you do sort of a parody or something that looks more like a parody or sort of a funny phrase, I think and of course, the shorter, the better. I think you're probably going to be okay. I mean, if you were to sort of do a second verse in the Bonnie Tyler song, I'm sorry, who did you say the song is from?
Yeah, Bonnie Tyler. Yeah.
Okay. If you did a second verse, you may be, kind of taking it too far, right? And then another question is that you said every now and again I fall apart.
Mm-hmm.
So is that original? Is that creative enough? Is that original enough as itself? Like perhaps like that's short enough, and that's just not original enough. Yeah, right. So there's so many different things to consider, but I think you'd mentioned like taking something from a tweet. So again, if it's a short phrase and it's sort of generic or not, arguably not so original or expressive, I think you're generally okay to take it. Like there was a case. Here's another example. Paris Hilton, right? She was famous for saying "that's hot." She was sued by Hallmark. They made a greeting card that had, probably like a cartoon, blonde girl or something saying "that's hot." She sued them. I don't know if I even know, like that case probably settled, right? So, who knows what happened. So there's so many like questionable things that, the question is, are you going to get sued? Is like if you're using something that's sort of a hot sort of IP, like Barbie, like Mattel sues anybody who gets, within 100 feet of anything that's Barbie. Star Wars as well is very, protective of their rights. I imagine that would probably go true for Marvel and Disney as well, right?
Yeah.
But versus somebody like I said, like Arnold Schwarzenegger, it's something you need to look. Some people are more litigious than others. If Arnold Schwarzenegger has never sued anybody for IP, that's something you'd probably want to know. Be like, okay, this is an Arnold Schwarzenegger quote. I think it's short. It's a parody. I'm not big time yet. And Arnold's never sued anybody. I think this is low risk. Yeah. So
I think, one of the things, exactly that, like, especially when you're dealing with, movies and TV, obviously there's a lot of that goes on. I would, like I say, recommend people stay far away from it as possible. But there are, there's like, well, okay, this movie was made in, 1901 or something like that. There's no estate that's going to have any rights to that movie. Let's say it's more kind of almost a public domain.
Public domain, right? Yeah. And right now, I think anything, I can't remember if it's 25 or 29. I think maybe 1925. Anything that was released before 1925 is automatically in the public domain. It's free to use. So, go back into some early literature or whatever, and even early 20th century, and not even probably. You're totally safe. It's public domain, right? And even some things before 1979, although that gets a little tricky of what is and isn't in public domain in that sort of window between 25 and 79. And the public domain date every year jumps another. So next year, assuming it was 25 this year, and I'm not misspeaking, it would be 26 and then 27. It just keeps growing. So one day,
the article of what's now in the public domain or whatever.
Yeah, and it would have been everybody. I feel like everybody knows like sort of the Mickey Mouse Act, right? That sort of extended that public domain in order to save Mickey Mouse, right? It was the Sonny Bono Act that prolonged the when the public domain was going to. Yeah, exactly. Yeah,
I think that's that's one of the biggest things here is if it's something that overlaps with some there's some IP, there's some person, there's a movie, there's a TV show, and they're already producing merch or something, and there's any kind of like commercial damage you could be doing, even if just assumed, you might be like, oh well, I only sell one shirt a month. Well, it doesn't matter if Monty Python or whoever it is comes along and says, well, we sell merch, so we're going looking for anyone doing Monty Python related stuff, and we're taking it all down. So it's those kind of situations. If you're doing something about some obscure comedy troupe from the 1920s that nobody knows about anymore, then you're okay. But if you're doing
sort of like the Who's on First, like if you were to do like a Who's on First, Abbott and Costello, right? I don't know when they came out, but let's assume they came out. They probably didn't, but
probably didn't,
somebody earlier than that, right? So, I was kind of thinking while we were talking, the funny line I remember from the TV show Friends, right, was, we were on a break. Ross, screamed, "We were on a break." Mm-hmm. Short phrase. I think that would most likely be okay. However, if the official Friends, I'm sure they license, and I'm sure there's license to uses of Friends. Mm-hmm. If there's "We were on a break," Friends T-shirts, and it kind of got to the point where it was associated even by this merchandise that's come out now. It'd be one thing if it's just in the show and left alone, but let's say that they start merchandising with that on there. Now there's claims of trademark, even though maybe they don't even have like a registered trademark in that, but it could still be or sort of false association with the Friends brand. So you kind of have to do your homework and make sure if you see something like, oh, that's I saw a Friends shirt the other day, it said "We were on a break." I think that's great. I don't need to license this. I'm going to do this. And then taking your thing, right? Let's say you say "We were on a break" and you have like a Kit Kat splitting in half or something. I don't know. Does that change it? Does that now make it a parody or kind of remove it from the Friends thing?
Yeah,
potentially, right? I mean, it gives you an argument now, but that doesn't necessarily mean that a very protective brand isn't going to still go after you. So the safer way, if unless you're somebody who's willing to sort of put your money where your mouth is, safer way is to sort of avoid those scuffles.
Yes, absolutely. Which would be my recommendation and my preferred route. And like in the early days, I was playing relatively fast and loose. I never did anything like Star Warsy or anything like that, but I'd pick a movie from my childhood and maybe do some fun designs around that. Obviously, you still see that stuff online, but if you're doing something that's on the hottest topic, then you're going to be in serious hot water. And even, I'm extra cautious now. So even that example you just gave, I'm on a break with a Kit Kat or something.
Don't steal that.
It's funny. You might post it on Instagram or something. Right. But as soon as you start selling that, it's just like, oh, do you really want to even tempt, Warner Brothers or whoever it is to, do a cease and desist? I suppose you could say, well, the worst that could happen is, it gets taken down. That's probably where the story ends. But, how much do you want to, potentially end up in hot water or try and defend that? It's just kind of creating extra headaches. So.
Yeah, that's the best you can hope, right? Is you get a cease and desist in there. And I see it more with trademarks than copyrights, is sort of the cease and desist where they are happy for you just to stop using it and they don't ask for money, or maybe they ask for money, but you say, I'm not paying you money, and they're like, okay, just take it down. Yeah. I see that more for trademark than with copyright. Usually with copyright, people will go for damages. So there's a difference there, but yeah. As you said, the best you can kind of hope is to just kind of have it removed. I had another thought, but I forgot it while we were talking.
Okay. Well, so we spoke a bit there about, what are some of the things I can create, what's okay to do, and obviously some of the main questions there. Let's talk a little bit about I've created something, it's original, it's my own thing. How do I go about protecting this? And one of the big questions is about copyright registration. Now, let me just pull up one of the questions we had here and try and get into this. I mean, we had a few specifics on copyright registration, but I mean, do you just want to give us kind of the headline kind of stuff? Like, why should an artist register their work with the Copyright Office in the first place?
And so obviously my advice here is US centric, right? I do like US law because in Europe, I'll just sort of say in Europe and in the United States and everywhere else, you have an automatic copyright. As soon as you fix something in tangible medium and it's a creative expression, you own a copyright in that thing. So you hear sort of, you know, I keep hearing things where I thought like, these must be like really old myths that don't happen. But I had a client just last week tell me that, she'd heard that you can, mail yourself your artwork, and now based on the postmark date, you've got it's sort of the poor man's copyright. Unnecessary and totally, I guess, untrue. The only thing that would protect you against is if somebody were to come after you and say, you stole my design. I created this in 2015 and, I see you using this, and you say, no, look, and you could probably fake it anyway. Right. But, here's my date stamped thing. I created this in 2010. So, obviously, you copied me. I didn't copy you. Yeah. Maybe that works in that case, but that doesn't work if you're trying to go after somebody. So why register your copyright? And I recommend, even if you're not in the US, but you have, merchandise that's sold in the US, to still consider registering your copyrights in the US. And here's why. US law is, for the most part, is very copyright owner friendly. It sort of, I feel like it's sort of going the other way on some issues, but for the most part, the basic law is that by registering your copyright, you open up the door to getting attorney fees. And at least in America, we have the American rule, which basically says everybody pays their own way in court. So, if you sue me, you pay your attorneys and I pay my attorneys for getting sued. However, that isn't always the case if there's a statute that says that there's fee shifting. And copyright actually has that, where it basically allows the plaintiff, and in some cases even the defendant, and that gets a little, that's a whole nother topic, when a defendant can actually get their attorney's fees. But generally speaking, for now, a plaintiff who has a registered copyright can at least seek their attorney's fees, and in the most part, they can get their attorney's fees if they sort of walk the proper steps and didn't do anything overly egregious, or the other, or it was such a questionable case and the other side had this like amazing sort of defense, and even though they lost, it was still like, it furthered the copyright laws, and it was, thank goodness we were able to get this on the books, because now we have a decision on this topic. Generally, you get attorney's fees. And then you also get statutory damages. So statutory damages are, especially, the minimum for statutory damages can be $750. It can go up to $30,000. And if you can prove willfulness, it can go up to $150,000. Good thing to say about that. Most people say, I can get up to $30,000. I want $30,000. It doesn't work exactly like that. There has to be some sort of reason for the statutory damage. Somebody's not going to, put your picture on their blog and you're going to automatically get $30,000.
Right.
The bigger the offense, obviously, the bigger the damages can be. Yeah. But speaking practically, I have clients who come to me with unregistered copyright. So, for example, let's say you're a photographer, just to make this easy. And somebody uses your photograph on their website. In a situation where you have a registered, and it has to be registered before the infringement started. So you can't just sort of, register it and after you find the infringement. You have to have registered it before they started infringing. So sometimes you might find an infringement, think that, let's say you have a registration that you did in 2017, you find an infringement in 2019, they can prove that they actually started infringing in 2015. Well, now their infringement predated your registration. So statutory damages and attorney fees are off the table. What that means, most of these cases for infringement end up getting settled because it just, a lot of times they're small enough dollar that it just doesn't make sense to take it to court. So only the big ones really go to court, or somebody who really just, wants to take it to court on principle. But so for this photographer, let's say that they didn't register their photograph. In that situation, you may be lucky to get away with whatever, you can make an argument. Well, my client licenses photos for $1,200 a pop. So, at the end of the day, with some attorney work, you may get $1,200, but how much is the attorney going to cost? Yeah. Unless they're doing it on contingency, but now let's say it was registered. Now you're in a situation where you can ask for, based on different, districts, courts or circuit courts in the United States, some courts have recognized up to like 7-time multipliers of the attorney or of the license fees. So now you're in a situation where maybe you're asking for like $10,000 plus attorney's fees. So, that's obviously a much, 10-time, multiplier when you include the attorney's fees than, between a registered and unregistered work. So that's the main benefit of registry. A lot of times, so I take on cases on contingency. If a case doesn't look like it has enough potential, and it wasn't registered, I won't even take the case, right? But and I will take unregistered cases if like the damages look like, usually if it's on products or something, you find like a big box store selling products, then that, even if you don't have the registration, it's worth it. But
so what about, let's say I've created some artwork, it's been selling well on, say, Redbubble and merch by Amazon and stuff, and then it's been copied and it's been sold on, copycats are selling it on Redbubble and Amazon and stuff like that. Is that a case where if I haven't registered the copyright before I started selling it or before it started getting copied, there's really no point registering it now, or would there still be a point in registering that copyright?
Yeah, that's a good question. So I would say that if you're getting copycats, maybe that means that your design actually, there's something to it, right? I mean, if you've got thousands of designs, it can be cost prohibitive to try to register all those designs. Even, going back to registration, it used to be prior to, I think, 2019, you could register an unpublished collection and it could have as many images in it as you want. Now it's only 10 images for $85. So the best you're ever going to do for copyright registrations is basically get them at $8.50 a pop until they raise the price again, and then whatever that's going to be, probably $10 a pop. So that's best case scenario. So even then, it can kind of get pricey. And I do recommend to people, while we're sort of on this topic, that, as you create collections, before you publish them, and what is published and unpublished is a whole nother topic that will rabbit hole if we go down, whether it's published or unpublished, before you publish something, register them in collections or groups of unpublished groups of 10. And then that's the best way to sort of get bang for your buck with copyright registrations. However, let's say that you didn't register it and you see somebody copying it. Like I said, that could be a sign that maybe this is a popular image and you do want to copyright it. Doesn't mean you're going to be able to use that copyright to get damages and attorney's fees in those cases that you cite it, but maybe there'll be a future case where you will be able to.
Okay.
In those cases, it's still nice, like whether it's right or wrong, it does hold clout when you're sort of sending DMCA or takedown letters to the Redbubbles and the Amazons to say that you have a registration and a image. That gives you a little bit more. I mean, you can go at them with an attorney. I've had clients who've had to hire me where they've sent DMCA letters and were basically told, this isn't an infringement or for whatever reason, and I've had to come in order to make it work the way it should have worked the first time, right? I say this even with, now thinking one client who had a registration. So I was about to say the registration, maybe kind of stands in the place of attorney. It kind of gives you some clout, but even in that particular situation, the registration wasn't even enough.
Yeah. So it can just be one of those things that just helps push the credibility or whatever, or the,
Okay.
they might pay attention a little bit more if you've got a copyright registration than
Right.
if you were coming in blind, which makes sense. And I thought we just got this question here from Jason, which is kind of on a similar topic. So I'll pull this one up just because it's one I wanted to get to as well. What is the best thing to do if someone has stolen your artwork? You issue a DMCA takedown and they counter notice your DMCA takedown.
Yeah, that's a great question. I mean, you're going to make me jump on a soapbox, Jason. But so what's going on? And I almost hate to like share it here in a public space because I don't want to give anybody else any ideas. But what's going on is there's so much infringement, and it's all coming out of like the Far East for the most part. And what's happening is, you get, let's say you're on Amazon, you're selling your product, or let's say they're using your image and they're selling a product on Amazon. You send a DMCA takedown to Amazon. Amazon takes it down. You don't need an attorney to do that in this situation. And Amazon takes it down, and then they get a counter notice. And Amazon comes back to you and they say, this person says they have rights to use your image. We're in 10 days, we're going to put this product back up onto Amazon unless you send us a lawsuit, filed lawsuit, and then we'll take it down. So the DMCA gives you that right. And basically it says, like, there's a whole counter notice that says, I agree to jurisdiction, wherever you want to sue me, sort of thing. And it's a good thing if everybody's kind of playing on a level, playing field, and somebody's really issuing sort of a wrongful takedown. What's going on is that foreigners have figured out that this is the quick way to get their products back on. And what's your solution as the artist, right? Now you've got to go find an attorney, pay an attorney to file a complaint. It's $400 just to file a federal lawsuit. Just in fees to the court, not to mention how much you're going to have to pay an attorney, which will be like, a few $1,000s to draft up a complaint. So let's say you do all that and then you file it. Okay, now the product is taken down. So you're like, well, at least it was worth my $3,500. Until, a month later, they create another account and, under a different name and a different bank account, and it's back on. And, there's unfortunately there's no way to really defeat that. I've actually written to U.S. Congress to ask them to try to figure out a way to sort of shore up that hole, because it's a law that's meant to protect people, like rightfully protect people, but now it's being used as as a weapon in the wrong way, right, and in the wrong hands. Yeah,
and it's something I know a lot of us here will have dealt with. Ken's here saying DMCA is broken.
Yeah.
And we've all dealt with it. And I think, in my opinion, the issue, like you say, there's obviously this legal loophole, but really I would like to see the platforms themselves take a bit more responsibility. And, instead of just saying, oh, it's DMCA, you said, it's he said, she said type of situation, we just hold our hands up and don't get in the nitty gritty of it.
Right.
I think, if Redbubble, if Amazon, take a look at my case, take a look at his case. Here's my design. This is his design. Can you have some eyeballs on this? Can we have a bit more responsibility as the seller, to do something about it? But
yeah, exactly. It honestly, like, it's like the one issue that infuriates me the most. The DMCA, it means well, but it's being misused. It's being abused by not only, in the case I just said, but it's being abused by the Redbubbles and the Amazons. They're hiding behind it. They know, we'll pick on Amazon. They're big enough to pick on, right? They know that there's infringements galore going on in their website. They should also, and when the counter notice comes, who should you believe? A U.S. person who's the artist, who has like a whole portfolio website with their name and a registration, and a U.S. attorney sort of swearing under penalty of perjury that this is right, or some unknown person that only has an email address and is located in China somewhere? Like,
yeah, it's pretty obvious.
Yeah, it's obvious, but that's a big hole.
I am hopeful. I think that we'll eventually get there. I think whether that's through, like you say, more attention on it and know your customer type stuff, so that if you want to sell on Redbubble, hey, you've got to show us a passport, show us a portfolio, more of a curated marketplace type of thing.
Right.
I think that's where we'll eventually get to, hopefully, but
right.
yeah, right now it's not much fun for those of us who are dealing with loads of counter notices on a daily basis or something like that. But
right, and similar to that, are we picking on these companies right now?
If you don't want to bite the hand that feeds us, but at the same time, we want to nibble a little bit on it.
Okay. Yeah. So, and I feel like I've seen some signs lately or recently where it does seem like some of these companies are taking this more seriously. For example, there's a rule under the DMCA that repeat infringers, you have to have some sort of policy for a repeat infringer. And there's no, like, is a repeat infringer somebody that infringes, 3 times, or somebody that infringes 25 times, and there's no really rule for that, but at least they have to have a rule. And I have seen companies start to actually like enforce repeat infringer rules. There's been, and I've dealt with print on demand companies, and I feel like they're sort of coming to the table more than they used to. I'll quickly just throw out that, I was involved in a very large lawsuit that sued Zazzle. That's actually still going on. We went to court in 2017, and this case is still for a second time going in front of the Ninth Circuit Court of Appeals. And this time about on the issue mainly of attorney fees and whether attorney's fees should or should not be granted, right? But that court that case has definitely sort of resonated through the industry a little bit, and I think people are becoming a little bit more aware that, hey, the best part of that case is so I drafted the summary judgment in the very beginning of the case that basically, and the court found that, because Zazzle tried to hide behind the DMCA and say, like, no, we're just a internet service provider. The finding was that because they were actually manufacturing and shipping these products, that they actually had a financial interest in it at this point in time, and so now it was sort of outside the safe harbors of the DMCA. So
that's what we want.
We just want a little bit more. I mean, we want them to pay attention. I mean, one thing I argued in connection with the Zazzle case, and I don't know if it ever actually made its way into the court transcript or whatever, but my position, while we were working on the case, was there are, I guess we did kind of argue this. There's reverse image searching, right? So as an artist, and basically the excuse was, doesn't work. We're too big. There's too many images. It's sort of like, we're too big to comply is basically, how I read that. Right. Yeah. But, if I'm an artist and I'm finding infringements on your website, I should be able to, formally send you a letter that says, these are my images, and, put this in the reverse image search of your system. And when somebody uploads an image that matches my image, you should reject it. Now, the flip side of that, if I'm arguing for them, which I'm just now kind of thinking, going back to sort of the counter notice thing, is, well, what's to stop somebody from, claiming that they own rights to some person's other image, right? Yeah. Well, I've got arguments on the other side of that as well. It's a little bit different than the sort of the counter notice thing, but anyway, yeah. But that's what I think they should be doing. I think they should be reverse image searching, especially if at the very least, it's sort of they should get 1 strike or maybe 2 strikes. But if there's, if I've sent you 2 takedowns for the same image, I shouldn't have to send you a 3rd one. By now, this should somehow or another, my image should be in your system, and it should never appear on your website unless it's by me, right? Yeah.
And this is something we talked about previously, but let's say, I've created a work, it's been copied, I've filed a DMCA, it's been taken down. And then next week I come back, someone else has uploaded it, I filed a DMCA, it's taken down. Is that a case where you think there could be room for a legal case there that something you might take on?
Yeah, that's a great question. Yeah, because of the Zazzle case, I do get a lot of people who are like, they're ready to sort of jump on a POD website because they find an infringement. I'm still very weary of cases against print on demand unless there's unique facts, right? I mean, I think that they're right. I'll advocate for them for a second here. I think that print on demand sites are right for the first infringement, kind of like what I said, like for sort of the first strike. However, and so I would never sort of sue a print on demand website just because they allowed infringements on there. If there was a brand, like a trademark that was sort of unique, that may be a different story. Like, if you've got like a brand name and people, because it's easier for them to search by words as well. And also just sort of trademark rights kind of give you that extra. It's like, not only is this a copyright infringement, but this is a trademark infringement. That I'd be more sort of prone to jump on, sort of on the first, if there was like a lot going on the website, two images, maybe not, but a lot. However, so like the Zazzle case, that was, we ended up with $460,000 in damages on that case. The unique thing about that case, and what I like to sort of stress, is that we went for years sending takedowns and notices. And there came a time where I even just like had a phone call with the person who was in charge of sort of the monitoring department and sent him a portfolio of the art that was sort of in question. And they agreed to sort of go through their site and remove the images. So we had like 8 cycles of takedowns, this extra level of sort of a one-on-one, me presenting portfolio, kind of having a heart-to-heart conversation. And then, a year later, there was like 45 of the artist's images being found on the website, and it's sort of like, okay, enough's enough. Like, how much money do we have to spend on takedowns? So that was sort of the straw that broke the camel's back.
Okay.
So
for those repeat cases, it's certainly something people might want to.
Yeah. If it's repeat, if you keep, I mean, and so this is something that you almost have to like harvest, over like a year or more, right? Because it's, you want to make sure you have the copyright registration before, like, sort of, even if you didn't have it for the first cycle. And then let's say you register it, and then let's say you've made sure there's no more, and then more pop up. If you want to be really sure before you file suit or whatever, let's go one more cycle and do another takedown. And then if it pops up a third time, I'd say game on in that situation for sure.
Yeah, I think, I'm personally in that situation with stuff. We haven't registered the copyright, but I've filed takedowns for that design, I don't know, once a month for the past 2 years or something like that. At least. Okay,
so in that case, let's register that design, and then even if it happens one more time, after it's been registered, I think you've got something there.
Enough there to go after something, Or even if you're waiting like a few months, because I could probably, from where I am today, I could probably say, well, in a year from now, that design's probably still going to be getting copied. So
right, and this is a good time to sort of also point out. Okay, so let's say that you find it one more time, and let's say it's now registered, and we file a lawsuit. Let's say that whoever you sue made $2. You found it so quick, and they made $2 off that design. Okay. The question would be, how much is this case really worth? Is it worth the minimum $750? For a registered work? Is it worth more? Can you argue that it's worth more because, this is the 10th time you've had to do this, like, and you've got these back expenses, and hey, by the way, I want to see an accounting for all of these other images now, in the past. Now there's statute of limitations with copyright too. It's 3 years. So you'd only be able to like look back for 3 years as well. But let's, so there's lots of variables, but let's, we would want to kind of hope that at the very least that, all these other times that your image was used, that at least in the last 3 years, that there's something at least in the thousands of dollars that, sort of makes
makes
sort
that
of
a case worth taking
exactly, makes
like
the
you,
case worth pursuing, right? Otherwise, you're just kind of going after a $750 case.
Yeah, exactly.
Right?
Yeah. So I think, I mean, big learnings there for me are obviously register your copyright if you can for new works, and even if even if you haven't registered them yet, and you're still getting copied on stuff, or you even anticipate, well, this has been my bestseller for the past 12 months, probably going to be worth what did you say, could work out at $8 or something like that.
$8.50, for the
so it's going to be worth doing that, because at least you have that option in the future.
Mm-hmm.
If that starts getting copied weekly or monthly, can come to someone like you and say, hey, do I have a case here? Can we get me some damages? Can we at least, would it be worth my time just to file a complaint so that Redbubble pays attention and actually, prevents it from ever being uploaded again or something like that? So.
Right. And I offer a service to artists where, for the most part, doing a copyright registration yourself is totally doable. Mm-hmm. It's more doable than doing a trademark, but even arguably doing a trademark yourself is doable. The risk is sort of making the mistakes, and I've seen enough mistakes in copyright registrations that have proved fatal. That I used to, a long time ago, I just used to tell everybody, you can register your copyright yourself. But then I start seeing so many mistakes in them. So now what I do is I offer a sort of a package where I'll get on the phone with you, just kind of get to know you. I'll register, either a collection for you, or if you have like a published work, I'll do a published work for you. And then I'll do screenshots of sort of screen by screen. There's probably like 15 screens that you kind of have to go and answer questions, that I'll do sort of a page by page PDF of your particular copyright registration. So now you can sort of do it yourself moving forward.
Right. Okay.
And so
without making any of those mistakes.
Yeah, exactly. Cool. And then I also, and then part of that kind of allows you to kind of have an open line of communication as you do registrations in the future. Like if you're like, hey, I'm registering one, but this one's sort of based on a public domain work, am I supposed to do something different here? And now you sort of have access to me to answer your registration questions.
Yeah. Okay, cool. Look, we've gone over what I expected us to. We are not going to have time to get to any questions, but just one I just wanted to squeeze in, just because this one did pop up before as well, and we haven't got to it. But this question what about the concept of an art collection book? You've seen this idea, like people saying, I have to register individual ones. What if I package them all together and register that? Does that work, or am I circumventing the rules there?
I think what you're doing is you're opening yourself up to, like, I bet you would get a registration, and it does, like, it needs to be like a truly published book, to sort of bolster your position on that, like, sort of a Michael Essek, monograph, the early years or whatever. I think it bolsters your position to do it that way, and that you weren't just sort of trying to do an end round to that. PDF right. Yeah. Like a PDF. This is my PDF ebook of all my images. I haven't seen it. I've heard it like again and again, right? I mean, everybody asks this question. I don't think that there's been any court cases about it yet. I would be a little nervous about bringing a lawsuit on it, but here's what I can tell you for a fact. There has been law on, if, let's say, somebody were to, you did this, and let's say you found somebody who's infringing 12 of your works of art. If you had registered them the right way, or didn't do them in a book like that, you would have 12 separate infringements. So, potentially, let's say, statutory damages end up being like $1,500, or let's say $5,000, per infringement in this case. And let's say you had 10 infringements, now you're looking at $50,000. However, in this case, because you have a book, it's only one infringement,
one registration,
because they infringed your book. And that's pretty much been, at least in one or two circuits, that's been the finding. So now, instead of a $50,000 judgment or even settlement, if you will. Now you're looking at a $5,000 settlement. So you are, I mean, you're giving yourself some protection, but you're also sort of, maybe cutting your nose off to spite your face or whatever. I don't know. Come up with a clever metaphor for that. I don't know.
Yeah.
Right.
It's complicated, but yeah. So I think we get the point there. Like you can do it, but you could be limiting what damages you might be getting in the future by going that route instead of the proper, individual one for every single artwork idea.
Right.
So, right. Thank you so much, Jason. Let me just put your details up on the screen here. So, like I said, do you want to just finish by telling people how they can contact you? And
yeah, absolutely. Yeah, I'd like to give a plug to Stacy Bloomfield was on your show I think last week or the week before, and she has Leverage Your Art show or courses, and in July I'll be doing a I don't even know how long, maybe like an hour and a half or something, with questions around art licensing, and I'll probably go into more depth about some of these topics that we talked about today as well. But I want to give a shout out to her and her course. So, and for me, right? So you can go. I imagine your link's going to take them to my website. I help people. I've done recently. I've had a sort of influx of artists come to me with license agreements. And I work with art agencies as well with licensing agreements. But I will say that with art licensing agreements, if you're entering into a licensing deal for your art, sort of with a licensee, I recommend having an attorney look at it. And I say that not just because I want work or I want to give work to some other attorney, but in the multiple agreements that I've seen, in my opinion, it would have been pretty detrimental to the artist if they were to sign the agreement without sort of having my input. So, be careful with the license agreements that you enter. Don't just sort of assume that they're all the same. You could be giving away rights or, subjecting yourself to liability that you may not want to be doing. As I said, I help people with copyright registrations. I do trademark registrations. I do any sort of contract disputes as well, dispute resolution. And for the copyright infringement cases, I do want to sort of give a sort of plug for the fact that not everybody does infringement cases on contingency, but most of the cases that I do take them on contingency, which basically, the layman way of saying that is if we don't bring in any damage money from the case, you don't pay me. We basically just sort of split what we get, and if there's nothing, there's no charge to you, if you will. So it's worth. I know a lot of people who've just sort of like told me, "Oh, I've had infringements for years. I just haven't. I've been afraid of attorneys, or I don't want to like end up bankrupt because I've got $100,000 in attorney bills." With me, that it doesn't work that way. We just split what we end up getting. Otherwise you don't pay anything. And then, you'd mentioned the top of the show, sort of the 20-minute consultation. I do want to clarify that because that's gotten me in trouble. Similar to this, right? It's until you and I, you being the, you out there, our attorney client, it's not really sort of a legal advice thing. It's more meant for people who say, hey, I've got this business, I'm thinking of doing this and that, and we talk about it. It ends up being sort of a, and I sometimes these 20-minute conversations have gone into an hour because, it's somebody that, has lots of questions and lots of issues, to be transparent. Obviously the goal of those conversations is to end up, entering into projects that I actually am, earning money from and not, giving away for free. So just to be clear that, it's not going to be, here's my 20, I've got this, can I do this with this? I've got this. It's not like that type of call, just to be clear.
Yeah, no, I think I hope people will understand that. And I think, especially like I can say from my point of view, if you're selling and you're making, if this is your living or this is the primary income source for you, then having input from someone like yourself who knows the ropes is invaluable. And obviously, whether you're paying for it, which you should be doing, or whether you're just getting that initial 20 minutes where you get a yes or a no from you, am I the right client for you? Is this a good fit? Can you help me with this project? I think that would be invaluable for a lot of the people listening as well. So as it has been for me. So, okay, Jason, don't want to take up any more of your time, but I can see in the comments, lots of thank yous. People have loved it. Thank you so much. Very eye-opening discussion and thank yous and stuff like that. So thank you so much for joining us today. I know personally it's been, it's changed my viewpoint on a few things and opened up a few new ways of thinking, and especially about protecting my work. So thank you for that. And hope you have a great rest of your day. And thank you for spending time with us this afternoon.
Hey, thanks for having me on, Michael. And thanks to everybody who was watching as well.
Okay. No problem. Thank you, everyone. Hope you enjoyed today's session, and we'll talk to you soon. All right. Bye-bye.